This is the Real Footy Podcast. Thanks for joining this bonus edition of the podcast, looking at the AFL Tribunal. My name is Peter Ryan. Joining me today is my colleague at The Age, Danny Russell. Welcome, Danny.
Thanks, Pete.
Look, it's been an interesting year for the AFL Tribunal. It's never far from the headlines, and this year we've had a string of controversial cases, most recently Zach Butters and Lance Collard. Look, we saw hearings interrupted by an open house inspection that one of the tribunal members had to attend, barking dogs, and we've even had a King's Counsel sacked by the league after delivering a judgement that AFL headquarters couldn't stomach. So it's been interesting. And this week, in The Age, we're running a special series of stories looking at these tribunal sagas, the history of the judiciary, and we take an in-depth look at the case of St Kilda's Lance Collard, who was suspended for making a homophobic remark in the VFL despite his strong denials. That case took 8 hours to determine a final sentence. And it all begs the question, not only has there ever been a more controversial year for the AFL's judiciary system, but do you think we need a change, Danny? You've been looking at the tribunal system. What's your thoughts on where it sits right now and what might need to happen?
Tweaks, Pete.
Tweaks.
Change might be overstating it, but let's just jump in this little time capsule I've got here. Zip, 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 and we'll head right back to 1897.
You serious?
Yes,
right. There you
but
go.
Just briefly, we're not going to hang around here too long. Penalties for misconduct have long been part of the football industry, Pete. I was going to say since Joseph played fullback for Jerusalem, but I'm not really sort of sure how that fits into today's cultural landscape. But St Kilda were the first club fined, Pete, in 1897. They arrived 20 minutes late for a game on a horse-drawn cart.
Really?
For their maiden VFL match against Collingwood.
And they still beat Carlton.
It was against Collingwood, I was going to say. Yeah. But
really?
So there you go. I mean, I reckon the Saints board and members would have been pretty annoyed with that. So there's the first kind of little point of annoyance.
Yeah, so the AFL got involved and charged with misconduct and fined.
And fined. Yeah. Yep. So, okay, anyway, back in
That's
the time.
good to know.
Back in the time capsule, zippity-dip-dip-dip, bop, right? So here we are in 2005.
Yep.
Adrian Anderson overhauls the system, right? So he knows that things need to change. But
he was the football operations boss at the time.
And a lawyer, okay? Yeah. So he knew the legal system. What he could not have envisaged then, right, is tribunal hearings where a guy switches off his laptop, gets in his car, dials in on his phone while he's driving as a real estate agent to an open house inspection. He could not have envisaged that.
No, I don't think anyone could envisage that in 2005 in any walk of life. But the interesting thing with Adrian Anderson, and you correct me if I'm wrong here, he brought that in. It used to be, obviously the tribunal's got a long history and there used to be the players' code and all those sort of things, but they were relatively informal settings, even though you had club officials representing players. They might have a legal background, often they did. You then had the players' advocate, Ian Findlay, who was famous for that. There was also an AFL representative, and there were tribunal decision makers or chairs or whatever they called them back in those days who would run them. But Adrian came in with his whole sweeping system around points for offences and so on. And one of the things he did was introduce a stronger legal focus in that players were able to be represented by trained legal people as a basis. How did that change what we've got now? How did that lead to what we've got now?
He let the lawyers in, Pete.
Yeah,
it's like the vampire line, isn't it? Don't let them cross the threshold. But
so has every club got I think you've been going through this, that clubs have got particular people they go through to when they need some legal representation? They
do, yeah. And sometimes they're board members or quite often they're football fans of the club. Yeah. And they work pro bono, like they offer it up for free.
So cost is not as big an issue as some people might think around these tribunal
Probably not in clubland. The AFL does appoint legal representatives, like the chairman of the AFL tribunal, Jeff Gleeson, KC. Yep. But not I'm told not a huge amount. They get an
honorarium, I think, is the case. And I would suggest it's about 5% of what they normally would get if they're charging market rates.
Exactly. Yeah. But there's I think there's a couple of points to this, Pete. So back to that 2005 period when Anderson brings this in. Another thing he couldn't have envisaged. So you're talking about there's a room at AFL House where they all meet.
Yep.
Up until this
we
stage.
Used to go to them.
Yeah.
Yep.
So he couldn't have envisaged COVID lockdowns. So all of a sudden we're conducting these hearings now on Zoom meetings or Google Meet or whatever they're called, and that's when a dog runs into someone's bedroom or whatever and barks and interrupts.
I used to see the golf clubs in the back of the appeals.
Yeah, that's right. So you have that has changed, right? And you've got social media pile-on. So the iPhone is introduced in 2007, 2 years after Anderson's tribunal, and then you've got social media pile-ons, and then you've got these changes.
I reckon that's a fascinating point because I've long held the view that the tribunal makes some significant decisions and we have instant reaction, and it's almost whether we give it a tick as a community on social media or we are outraged.
Yeah. Well, and I reckon more of that when we probably get into the nitty-gritty of the cases. But so one of the motivating factors for Anderson and letting the lawyers in the door or the vampires over the threshold, however you want to look at it. So you go back to 96 when Sydney defender Andrew Dunkley plays in a losing grand final after winning a Supreme Court injunction to have his hearing delayed. So the AFL don't want the courts involved. So the courts pretty much will say, we won't come into your jurisdiction if you have a proper system in place. If you tick all the boxes off, then we generally won't overrule what your decision-making process is.
Yeah, that's interesting.
So you nearly have to have this tribunal system and appeals board system that has legal representations. The other big point is that a billion-dollar industry, is probably fair to say the AFL is a billion-dollar industry. Players' livelihoods, and the money that is at stake and the reputations that are at stake.
Not to mention things such as Brownlow and so on.
Yes, in premiership medals. Thank you, Patrick Cripps, to 2022.
22 or 23, I can't remember.
22, yeah. And then he won in 24 without needing sort of legal intervention.
Yeah, okay.
But the lawyers that we've talked to in the sourcing of this piece say players deserve legal representation because there's so much at stake. It's a high stakes game, AFL now.
Do you agree with that? I mean, lawyers are obviously have a vested interest in saying that, and I'm not disputing that's a reasonable position. But do you have a view? Yeah,
look. If I'm sitting in a pub and we're talking about these cases, I'm probably going to say, why do we need this sort of legalistic kind of approach? Let's just deal with it as footballers after a game. But in reality, that just is going to open the door back to the Supreme Court. They're going to start crossing the road to the Supreme Court, and then that's a bad look. You just don't want that happening.
Well, one of the things, and we'll touch on it, is the Lance Collard. There was some suggestion by St Kilda that they would have been prepared to take the matter further if he hadn't received the eventual suspension of 4 weeks with 2 weeks suspended. We'll never know whether that was an idle threat, but that was one of the things that they were contemplating depending on the decision. You mentioned Patrick Cripps and the legalistic component of the tribunal. The other thing I discovered in researching around Lance Collard is that Murray Callum's decision that upheld Carlton's appeal, which led to Cripps being cleared and eligible for the Brownlow Medal in 22, was based on a rule of law that the tribunal chair had not directed correctly before they debated the verdict, which wasn't really cut into the chase of whether he'd actually bumped someone illegally. And that has led to these long-winded legalistic processes that they now are forced to go through because of the fear that it could be overturned on a rule of law. Even though the AFL changed the rules after that to make it less likely, they still are obliged to go through those things that make the likes of David Zeta, who's made a name for himself with Fox Footy Twitter and does an amazing job, roll their eyes about, and most footy supporters do.
Yeah. Gil McLachlan wasn't very happy, was he, with the Cripps case? And they did close that loophole. It's interesting, though, because it also then asks the question, how independent are these appeals boards?
So what have we got? We've got the tribunal, we've got the MRO, then you've got a tribunal, and then got the capacity to appeal to an appeals board.
That's right.
That's the system.
Yeah.
And the tribunal chair is Jeff Gleeson KC, and then we had the appeals board chair was Will Horton KC. We'll get onto that. It was sacked after Lance Collard. That's the process.
Yeah. Starts with Michael Christian.
Yep.
Who's the MRO, which is that was a smart introduction. It was the match review panel for a start.
Yep.
So there was a panel rather than a singular person. But it's football people making judgments on football actions, and with a sliding scale. Yep. So you can offer up penalties that can be accepted, and that just cuts out the whole fronting up to the tribunal waste of time process. Yep. If you've got an issue with that, you can challenge. But if Chriso sees something as being difficult for him to kind of determine, he'll then refer it straight to the tribunal. Yep. Tribunal makes a ruling on the initial appeal or on that referred case, and if you want to take it further, you take it to the appeals board.
Do you think, having watched the Zach Butters case unfold, and it became a bit of a laughing stock for the tribunal because of the way it was conducted, and he actually had his penalty of $1,500, I think it was removed, wasn't it, based on the fact that the tribunal initially hadn't really been in a position to hear it properly because of the... What did you learn out of the Butters scenario? Was it right to criticise the tribunal overall, or was that just one out of the box that they didn't get right?
Yeah, so my view initially on the umpire Nick Foot, Zach Butters case, which was disputed, what he said over umpire abuse, was that, and I think this is a general consensus in the football community, that one probably shouldn't have got to the judiciary. That might have been mediation would have sorted that out.
Mediation, and Greg Swan should have been able to force Nick Foot to actually appear in mediation. If they couldn't actually get to an outcome, then it could have gone to the tribunal. Yeah. But he chose to back Foot and say, well, fair enough, Foot wants to go to the tribunal, so we'll take it. But I'm uncertain whether he had the power to force him to mediation, but he should have the power.
Yeah, I think that's right. I think he tried.
Yeah. He definitely tried. Yeah. It's just whether he wanted to enforce a power. Yeah. I'm not sure whether that power exists.
Yeah. But then it descended into a farce. Yeah. So this was a really controversial case before it even got to the tribunal. Yeah. But the system in place, it's fair that it heard this and it's sat in a fair way, but not when a tribunal member, and Jason Johnson has more or less apologised for this. Yeah. He tried
to juggle things, and I know for a fact that he was juggling dates. They wanted to get it done quickly. Yeah. There were times changed several times during the day. No excuse for that, but he just got it wrong.
Yeah. And so it's human error. Yeah. The system's fine, human error in that case. Yeah. I would think there's another lesson in this, is that perhaps you need all parties in the same room. So when you're cross-examining over laptops and Zoom meetings, some feel that it loses integrity because you can't sort of look people in the eye when lawyers are interrogating you, basically, in a cross-examination sense. I think that's like a court of law. You need to be in the one room. So whether they fly Butters across or whatever, and it's not always convenient, but if you want a fairer outcome, I think that's something that the league will look at.
Yeah, okay. I mean, it was ridiculous to think that they should have full-time tribunal members, I would have thought, even though some people called for that because there just wouldn't be.
No, it's not the case.
One of the things that they also brought in, which people often forget, is that there's a lot of former players, Jason Johnson being one of them, that sit on the tribunal, which actually should lend some credence to these people who are making decisions not just based on law, but based on experience within the game. Yeah. I would say that I'm not necessarily a defender of the legalistic processes, but they've done it. They copped a lot of flack for their heavy-handed approach in terms of the sling tackle, the bump, some of the things that are protecting head-high contact. I would argue that, and I know these figures are down, dump tackles are way down. Yep. Head-high contact seems to be. I mean, there's always going to be the occasion when it happens, but seem to be down. And that is a result of the tribunal having, and the MRO, having the, courage of their convictions to continue down the path of applying heavy penalties, which have changed behaviour.
The system's worked in that sense, hasn't it? So as a father of two young boys in junior football, that's a result I want to see. That's what I like. Even though we had an opposition kid at the weekend who had about 50 possessions, and I was hoping the kids might tackle him a bit harder.
So why the uproar?
On the tribunal now? Well, I think it's because it's interesting. Andrew Demetrio, as part of our process, said that by round 7 and 8, every year his knowledge of football was the worst umpiring, the worst tribunal decisions. You know, it just is a yearly kind of pile-on. And by the end of the year, when we get into finals and grand finals, the umpire decisions are perfect and, you know, and the tribunal rulings are spot on. Look, I think it's because we've had these two unique, controversial decisions. So you had the disputed umpire abuse, which in itself was, became a huge talking point. Then you had the way in which the tribunal played out. Then you had the appeals board dismissing the case on an error of law because the tribunal member got in his car and drove off. But then you've got this the appeals board case. Now this is coming back to our original point. The system works, but is it the human error or the human element of the chairman making a controversial remark that caused the blow up?
Are you referring to the Collard case now? Or
Yes.
Yeah. So the Collard case I've looked at and sat through a lot of that thing. There are a lot of fault lines that are exposed. I think both the Butters case and the Collard case had things in common in that they were both contested evidence in terms of one person was saying that they said something.
Yes.
And the person who was on the receiving end of that comment was saying that they heard something different.
Yep.
So one of the issues that arose in the Collard case, when that happens, previously Lance Collard, just to take you back, was accused of making a derogatory homophobic slur in a game against Frankston, of which two Frankston players said they heard him use the slur. He said that he hadn't in fact said that word and he'd said maggot. And that gave the AFL the opportunity to either take it to a conciliation process through the peak rule, but it didn't qualify for that. He was charged with conduct unbecoming after the investigation or during the investigation. Charged with conduct unbecoming. They do the investigation. They're still holding their positions that are contested. So they could either walk past it and say we can't come to a conclusion, or they sent it to the disciplinary tribunal, which would have happened anyway if he'd gone via the peak mediation process. Does that make sense?
Yeah, so let me ask you a bit more about the Peak mediation process. So I believe this was a process named after Andrew Peak, is that right?
Tony Peak.
Tony Peak, sorry, Andrew, but and sorry
Tony
to Tony.
Tony Peak.
Yes.
Iconic figure of the AFL.
Exactly. Yeah. So iconic, I've forgotten his name. That's embarrassing. So that was brought in when we were first exposing these
racial vilifications. 1995, the peak rules introduced. Then 2013, it comes into sexual orientation and various other things that if you vilify or denigrate someone, you can be into the peak rule. But to actually go through that process, the person who's been vilified has to have one of those attributes that have been referred to.
So if
you're just been a general comment to the wind.
So there's a victim in a sense.
Exactly.
And so in the Collard case, the player that heard the homophobic slur was not homosexual, so it's a judge that he's not necessarily a victim, but it's the wrong
it's
behaviour.
the wrong thing to say. So it's conduct unbecoming.
Yeah. But do you believe though, even though there's not a specific victim, they still should have gone through the peak rule?
I don't think they should have in this case. I think they need to address it now and work out whether they have a bespoke or variation on the peak rule that actually deals with things such as homophobic language, where the victim is not necessarily going to declare themselves, or they're not necessarily personally offended, but it's the inappropriate word, and we don't want to have that on in the game. And you might be able to go through a conciliation process that actually provides a learning opportunity, rather than the ugly, brutal reality of what happened in this particular case, where it was contested and there was 11 witness statements. There were 8 hours of debate around first whether he was guilty of using the word or not. One of the participants, Darby Hipwell, who'd made the report, the Frankston player, he was on the stand, for the want of a better word, for 54 minutes. He's doing a job. He's a VFL player. That's a really difficult process, and one that potentially makes people reluctant to report such incidents in the future. Then had Lance Collard sitting in a hearing where he was not necessarily able to give great evidence. Again, going back to your point around being in the room. Then we had the sanctions submissions around his life, where a lot of stuff was aired that may or may not be considered relevant in a football sense. And then Jeff Gleeson was came down with a penalty of 9 weeks, 7 weeks actually serving, 2 weeks suspended, based on the fact that the special counsel had, in previous cases that were similar, granted 4, 5, 6 weeks because they weren't contested. So because it was Collard's second offence, he decided that he should actually have a higher penalty, which is quite reasonable. But he did make the point in his judgment that whether those sentences were appropriate or not, it's quite an interesting judgment to read.
So St Kilda then appealed that on the basis that, appeal often has to be like an error of law, doesn't it? So we're coming back to this legalistic
thing, which is fair enough. They had to go through either an error of law, or they argued around whether it should have actually been heard under Rule 35, which is the peak rule.
Yep.
They failed on both of those issues.
Right.
But they did succeed on their argument that the penalty was manifestly excessive,
yes,
which led to Will Horton's now notorious judgment.
Yeah. Just winding back, though, a little bit.
Yeah.
So 9 weeks, 2 suspended, 7. So 7 weeks for a young VFL footballer is a massive amount of time. But the offence is serious. Did you personally view that as being in the right ballpark, or?
No, I personally viewed it. My position's been the same, rightfully or wrongfully, because I'm not sure what's an appropriate penalty, but that you needed to have a consistent penalty for these slurs at the start.
Yep.
3 weeks.
Yep.
4 weeks, whatever you pick your poison.
Yep.
And there was no point increasing the penalty, as the AFL said they would, for second or third offences by different people.
Yeah.
Which led to the case where Collard's got 6 weeks from the special counsel. You can debate the rights or wrongs of that. But then for him to have a second offence, different circumstances, certainly the tribunal felt that they had to increase it on that.
So then we get into almost one of the biggest talking points of this whole system. So you've got an AFL appeals board, you've got the chairman who's a KC, got this young man's kind of future in his hands, but in the end affects his own future with his decision and judgment.
Well, Will Horton came down with a decision where he, I'd be interested to debate this with Will because I'm sure he's got a better legal mind than me, but he came down with some, I think effectively what he was thinking was we shouldn't ruin this person's career with a 7-week penalty for a word that he used and he shouldn't have.
Yep.
And it should be he ended up with 4 weeks and a 2-week penalty, that it should be a lesser penalty, which doesn't lead to that. But in doing so, he delivered a judgment which explained the reasons for that, which outraged the community in saying that it was commonplace that players use racist, sexist and homophobic language in the game, which who would know? Yep. But I assume at the AFL level it's pretty rare, even though people are still being reported for doing that, recently as this week. And he also said that it was not offensive to the person who heard it, which really is immaterial. And he also made some comments around it being crippling to Collard's career, which wasn't actually tested as evidence. It was a submission made by St Kilda's legal representatives on Collard's behalf. So that led to a phone call from the AFL on which he was given his marching orders, Will Horton, on the Saturday, just a day and a half after the hearing, and also after an AFL statement. But it also led to questions being asked about the system. Yeah, the
system. So I reckon there's two elements to that. The penalty. So the AFL were annoyed with the penalty, reducing it heavily. But I think in the judgment, you can read that there's reasons for that. And it's an independent, inverted
commas, yes.
Independent.
They're not easy to get people to appeal.
Independent, even though he's handpicked by the AFL and paid a
That's true, but you
AFL.
do need, I would say that most footy fans would want someone who could at least draw a football.
Yeah. That's an interesting comment. Mine end up being more round than oval, I've got to say. But
but you know what I mean.
Yeah. So the penalty, okay. So there's legal minds that would say, okay, reducing that penalty is fair.
Yeah.
But it's debatable. Then you get into the judgment, and the comment specifically, and I think a lot of people took umbrage at the fact he's saying it's a hard game, but does that ever make any behaviour excusable? I'm not sure. Is it commonplace? I don't know. I haven't played footy for a number of years, so I don't know. I hope it's not, but I can't argue otherwise. But did they look into the rest of his judgment deeply enough? Because the next part from Horton sort of says he commends the AFL for stamping out this behaviour. So I don't think he's excusing the behaviour, but it's pretty clunky and it wasn't. He really didn't need to say commonplace.
He overcooked
from time to time.
the judgment rather than. I mean, you can still debate the sentence and so on, but I would say that he was certainly not saying that was acceptable behaviour.
Yeah.
He was far from saying that.
Yeah.
He was making a sweeping judgment about how common it was.
Yep.
And he was also aggravating people in the sense that your reaction to being jostled or so on might be to use something that's offensive to people.
Yeah. But we've moved, and so I went to the VFL on Saturday and Lance Collard was playing.
Yep.
And he played well.
Yep.
He moves well, kicks well, not a big guy, so his body might not be ready for AFL yet. But we've moved on from him, and it's all looking at the Horton judgment, isn't it?
That's correct. I mean, one person I spoke to said the great disaster of the Collard case was that it actually took away, it was all focused on the individual and the sentence and the judgment, whereas really it didn't look at the structural changes that were needed and the learning opportunities it might provide for stamping out homophobic language.
So I'll then revert back to the very start of this podcast, not the time machine rubbish, but do we need a review? So you look at the Johnson era. Now, the league sends out messages each week to all its people, and it said, this is not kind of acceptable behaviour for a tribunal member. So it addressed that, right? And then it sacked Horton.
Yep.
So it's addressed that. So it's addressed things. Does it need a review now?
I think it needs a review, but only, as you said, didn't you use the word tweak?
Yes.
It needs a review to tweak to see that it's got the appropriate mechanisms in place to actually handle the things that have been handled, generally speaking, despite, frustration with inconsistency and so on. The tribunal's done a reasonable job in that regard. The tribunal's actually more consistent in many ways than the AFL.
So can we call this the Andrew Tweak rule?
We might have to go
and then we're problem solved.
Yeah, well, look, the final point is we're going to examine both of these instances, the Lance Collard case specifically, and you more generally, on tribunal matters and whether it should be a review and why it may or may not be necessary to have such a legalistic system in place in the AFL in our series in the Age this week, which I look forward to reading.
Exactly. And I think once you read our pieces, you'll be able to make an educated view on what you think should happen.
Absolutely. Yeah, I feel like we've done the law report. That's all we have time for today, Danny, and thanks for joining us. We hope you've enjoyed this special edition of the Real Footy Podcast. We're aiming to bring you a few more of these throughout the season alongside our regular Monday podcast and the Expert Tips instalment each Thursday. Make sure to subscribe, rate and review wherever you get your podcasts. If you'd like to get in touch with us, send an email to realfootypod@theage.com.au.